Hi everyone, and welcome to week 5. The term is flying by. Week 5 of Con Law 2, where we make the pivot from substantive due process to equal protection. Just a few points about the Equal Protection Clause in this introductory equal protection video, and then I'll move to Canvas Studio for some more detailed discussion of cases, and obviously get into more detail. Number one, to remind you, equal protection and substantive due process are not to be confused. They can both be issues in the same case, but they are to be treated distinctly and separately. Substantive due process is about rights, unenumerated constitutional rights, whereas equal protection is not about rights. We'll talk about a couple exceptions to that, of course, but let's talk generally first. Equal protection is not about rights, it's about groups or classifications or characteristics. Right. So the idea here is not just that you shouldn't be messing with my rights, but you shouldn't be messing with me if you're the government because of who I am or because of my membership in a certain group. Now, the first thing I want to talk about is a textual problem. You should now well know the doctrine of selective incorporation. And selective incorporation deals with when the rights that are enumerated in the Bill of Rights, the first 10 amendments, when those rights apply to the states, because the First Amendment says Congress shall make no law, and that's the lead into all of the Bill of Rights. So how is it that those rights apply to the states if what the Constitution says is that they apply to the federal level of government? And you know that the answer is that post-Civil War, after the 14th Amendment was adopted, after the Due Process Clause was made applicable to the states, and that clause, of course, including the word liberty, that as a matter of fundamental fairness, the court held that most of the Bill of Rights should now apply to the states. The states could no longer get away with violating people's freedom of speech and all that kind of stuff. When we have a 14th Amendment, which expressly targets states and really requires states to fair dealing, right, to engage in fair dealing with their subjects. Now, in the equal protection realm, we have the opposite problem. For the Bill of Rights, the question is, how do they apply to the states? For the Equal Protection Clause, the question is, how does it apply to the federal government? Because look at the 14th Amendment. The 14th Amendment says no state shall, right? When you get to the second sentence of the 14th Amendment, no state shall. So now we have an amendment that expressly targets the state level of government, and there's only one Equal Protection Clause in the U.S. Constitution. You know, it's kind of handy that there are two due process clauses, because one in the Fifth Amendment clearly applies to the feds, and one in the 14th Amendment clearly applies to the states. But there's only one Equal Protection Clause. We've talked about this before. The equality principle was not built into the Constitution as an original matter. It did not show up until 1868. So there's only one Equal Protection Clause in the Constitution, and that Equal Protection Clause is in the 14th Amendment. So how does it apply to the federal government? You might sort of call this reverse incorporation. Don't use that term on a bar exam, but it's just another way to think about it. Now, incorporation is how stuff applies to the states. Here, how does stuff apply to the feds? It's a similar idea to incorporation. Here's what the Supreme Court has said. There was a case involving Brown versus Board of Education, and in that case, in Brown versus Board, obviously, and we talked about this a little bit in our last live session, but let's get it on tape. There was a case accompanying Brown versus Board, and the question was whether the Equal Protection Clause applied to the District of Columbia School District, the District of Columbia being under federal jurisdiction. And the court said that even though the 14th Amendment on its face applies to the states, we're back to this again. Due process, the whole concept of due process, the underlying principle there is fundamental fairness in governmental dealings with the population, with the persons under the government's jurisdiction. And then the court says the Equal Protection Clause is all about the same thing. The equality principle is all about fundamental fairness. Whether you're talking equal protection or whether you're talking due process, the whole point is that the government is not supposed to engage in arbitrary rulemaking when it comes to its subjects, right? The people who are living under the government's jurisdiction. So the court says in this companion case to Brown versus Board of Education, due process and equal protection, now kind of in your mind, keep them separate, but the underlying principles are very similar. So the court says we do have a due process clause that applies to the federal government, and that due process clause requires that the federal government not be arbitrary in its dealings with the people under its jurisdiction. And basically the court says, it's very much the same idea as incorporation. It really couldn't be, this is the court talking, that the people who drafted either the Fifth Amendment or the 14th, the Bill of Rights or the 14th Amendment, that in restraining one level of government, they were leaving the other level of government free to do exactly to engage in exactly the kind of misbehavior that they sought to stop the government from engaging in. And if you think about it, it doesn't make a whole lot of sense. If I live in Florida, it doesn't really matter to me who's putting me in jail because of my opinion. Whether it's the federal government or the state government, the point is what? I mean, I can't, don't tell me I'm living in a free country if I'm in jail because of my opinion. And it doesn't really matter to me whether it's the state discriminating against me or whether it's the federal government discriminating against me. If the government is discriminating against me, then I'm being discriminated against. So the court has never bought into this whole, let's treat the two levels of government differently when it comes to rights and equality. Bottom line, the court has said that the Equal Protection Clause, the Equal Protection Principles embodied in the 14th Amendment, this is how you'd say it on an exam. The Equal Protection Principles embodied in the 14th Amendment, they do apply to the federal government, but you have to plead this correctly in your complaint. They apply through the Fifth Amendment's Due Process Clause. So how does the Bill of Rights apply to states? Through the Due Process Clause of the 14th Amendment. How does the Equal Protection Clause apply to the feds? It's through the Due Process Clause of the Fifth Amendment. There are your sort of incorporation and reverse incorporation ideas, and those have to be clear in your mind as a textual matter when you launch into an analysis. I'm going to stop this video right here and do another very short video about the context for understanding the Equal Protection Clause and some of the reasonable limits on interpreting the Equal Protection Clause.